Thank you for checking out SNU's Contract Bank. I'm Roxanne Smithers, co-founder of Smithers & Umewabo, your trusted 360 general counsel. This video provides a brief overview of the Master Copyright Services Agreement. It is specifically tailored for individuals who provide copyright services to their customers and clients. It's designed as their master agreement so that you can utilize it repeatedly with multiple clients. And also, if you have clients where you have repeat projects for them, you can utilize the services schedule to cover each additional project without having to negotiate the contract terms over again with your customer. So let's get into it. So the first section that you'll see in this agreement deals with your fees and expenses. Obviously, this is very important. You want to make sure that you detail how you will be paid and whether or not your client will be responsible for any expenses that you incur while providing your services. It details the type of invoices, as well as if you are going to require a deposit in order to start your relationship and start the project with your client. Paragraph 3 covers changes, how the parties can modify this agreement going forward, or if they want to make one-off modifications on a project-by-project basis. In order to modify the agreement as a whole, the parties would have to do that in writing in an amendment. But if you want to make one-off modifications for a specific project, then you can handle that in your services schedule. Section 4 details the services and responsibilities of the copywriter. This discusses the deliverables that you're going to provide, the effort that you are going to put in, as well as the type of client input that you will expect and need in order to provide timely deliverables. Paragraph 5 details the responsibilities of your client to provide information, to review deliverables in a timely fashion, and to make sure that that client input is both accurate and timely as well. There are some other responsibilities. If your client would like your deliverables in a specific format, the client may take on the responsibility for any additional licensing or software fees for that specific format or program they want you to use. Paragraph 6 covers delivery and acceptance. It details the process for you to make your deliverables available to your client, the time that your client has to review those deliverables and accept them, and what happens if they are not accepted. Paragraph 7 covers intellectual property rights. And this provision details who owns the information and the content that you create as part of those deliverables. The way this agreement is set up, you will maintain ownership until your client pays in full for those deliverables. Paragraph 8 covers any representations that you make with regards to the quality of your services or the results that may come from your services. Paragraph 9 covers what happens if either party receives confidential information during the course of this agreement. It states that you will maintain the confidential nature of any confidential information your client provides to you, and your client will do the same in turn for any confidential information that you provide to them as part of you providing your services. Paragraph 10 covers the duration or the term of the agreement. It also details how the parties can terminate the agreement or terminate a specific schedule of services. There are options for either situation. Details a timeline for that, the type of notice that has to be provided, and what happens for any payments that are due and owing at the time of termination. Paragraph 11 covers limitations of liability. Limitations of liability are essentially a cap on either the dollar amount or the type of damage that you might be responsible for if your client incurs any loss or damages as a result of your performance or non-performance under the agreement. This provision goes hand in hand with paragraph 12, which is a mutual indemnification provision. In sum, this provision states that if either you or your client fails to follow the terms of the agreement or perform in any inappropriate way that causes damages, losses, or claims to be brought against the other party, that you will be responsible for that. And of course, that's going to be subject to that cap that we discussed in the prior paragraph. Paragraphs 13 and 14 make it clear that both you and your client are free to provide services or obtain services of a similar nature from other parties. This is not an exclusive agreement. You're not an employee of your client, and your client has no power to bind you to any legal obligations without your permission. Paragraph 15 states that whatever state you are registered in with your business or state that you live in, the laws of that state are going to govern this agreement. Paragraph 16 covers what happens if you or your client end up in a dispute. The parties are first required to negotiate. You have the option to elect that the parties will mediate the matter or that the parties will go to arbitration to resolve the matter. This provision also states that whichever party is successful in pursuing the dispute, that party will have an opportunity to recoup their attorney's fees and cost. Paragraph 17 details how the parties are required to give notice to each other with regards to the agreement and with regards to any performance issues in the agreement. We always recommend that notice is provided in writing, even if you have a verbal conversation, that you follow that up with at least an email. Paragraph 18 states that if there is a dispute, how this agreement will be interpreted by either a judge or an arbitrator. And paragraph 19 states that if the judge or arbitrator finds that any provision of this agreement is not enforceable, that the remainder of the agreement will still be enforceable. And then finally, paragraph 20 details that the full term of your deal with your client will be laid out in this agreement. So if there were other verbal commitments or discussions that are not detailed in this agreement, that neither party will be bound by those. So you want to make sure that everything that you have negotiated or agreed to with your client is detailed in this agreement. And then finally, you'll have your services schedule. That again, this form can be used over and over again to create new projects for your client if you have a recurring client. You're going to provide a description of your services, the deliverables to your client, and a time frame for your performance and your services. It lays out how you're going to be paid. You have options to be paid by the hour, to be paid flat rates. It details how many revisions are part of your flat rate and your cost for additional revisions. If you're requiring a deposit for your services, and the timelines by which you expect to be paid. You have an opportunity to detail any expenses that the client will reimburse you for, and also your hourly rate if there are any services that your client requests that are beyond the scope of this agreement. And then there's an opportunity for those one-off modifications to this agreement. So this master copywriting services agreement covers the full range of issues that you may face as you're negotiating terms to provide services to your customers. If you have any additional questions or would like to talk further about the agreement or talk further about your business, you can always schedule a consultation with one of the attorneys at Smithers and Wabo. We want to thank you for visiting the Contract Bank. And once again, I'm Roxanne Smithers with Smithers and Wabo, your trusted 360 General Counsel.